Hi, everyone. Hello, we're going to get started very shortly here. We're waiting for a few people to finish joining us. And this is estate planning A through C, wills, trusts, and more. So I hope you can hear me fine. And we're also going to be giving you an opportunity at the end of the presentation to reach us with any questions that you may have about your own situation. So, this presentation, and I like to think of it more as the beginning of a conversation because it is a time when you can learn a little bit about your own questions, your own situation, your concerns, but also take it a step further. Not just get the information, but know what to do if you decide that you want to put some planning in place. So we call it planning to say how much you care because when it comes to estate planning, it's really not just about you. It is about you in terms of making sure that your wishes are honored, making sure that whether you're here or not, things will happen the way that you want regarding your own asset and your family, your decisions. It's also about your loved ones because it is about protecting them and giving them the best possible future. So, this is planning to say how much you care. And a lot of clients come to me and say, well, can you do a will for me? And of course, we can do that. We have will based planning and trust based planning and much more. But I start to discuss with them, well, how do you know that you want a will or that you need a will? Um, what makes you think that that's going to help you or your family? And most of the time, they think that a will is enough because they think that naming their children, their loved ones, their spouse as beneficiaries is enough and that they will be set. The assets will be handled or received by them seamlessly, and it's not exactly the case. What a will does is that it forces you to file it in court or your loved ones, forces your loved ones to file the will in court in a process called probate, which really it comes from the word also proof. Your will has to be proved in court. So this is a time when accounts can be frozen. There could be family disputes and a lot of animosity because people think they heard you say something, they're not clear, they want to dispute what maybe the will says or doesn't say, and there's a lot of delay and cost, a lot of waste. So uh, there's a quote that a will and the probate process is a lawsuit that you file because it's your estate that you file against yourself with your money for the benefit of whom? Really, not the benefit of your family, but for the benefit of creditors, third persons. They get to have priority in the claim process. Everything stops for a while in months, sometimes until the creditors can file their claims. And this is a time also where there could be a lot of family dispute and a lot of pain because maybe mortgages need to be paid, accounts need to be settled, things that cannot happen until the judge says it's okay or issues orders, right? So you can avoid these pitfalls if you put together a solid plan. That's the good news today. And you can make sure that your children are set for long-term success by putting a plan. Today we're going to be talking about that, how you can accomplish that, or how can you find out more about it. So first of all, I want to introduce myself, and also introduce, by way of reference, my also partner and daughter, Raquel Tomas. She is our newest attorney in the law firm, and she also specializes in trust, Medicaid planning, and she's dedicated also to seeing clients through the complex process of estate planning and probate. So I am proud to say that she's an excellent person, compassionate attorney in our law firm. And as for me, I am the founder of Legacy Trust Counsel. I've been in practice for over 25 years. After graduating from the University of Miami, I realized that clients did not have a plan in place for the long term. And this is one of my passions today. I'm also the mother of 6, so I know what it feels like to want to protect your children in the future, even if they're adults. Mine are, because they're over 18. That doesn't mean that they still don't need my guidance and support and protection. So we're going to talk about that, but we're also going to talk about how to make sure that your wishes are honored for you. But before we dive into that subject, I want to ask a couple of questions, because I want to know if you have minor children or adult children. Basically, I want you to think about that. The planning that you put in place for minors is very different from the planning that you put in place when your children are adults. Because when they're 18, they're sometimes going to need even their own documents to authorize you, give you the power to protect them. And when they're minors, they're going to need another type of protection to make sure that if something happened to you today, unexpectedly, who would take care of them? Who would even know who to call? So these are things that you need to put in place. We call it Kids Protection Plan, and we're going to be discussing that. So when it comes to minor children, um, we put in place legal guardian nominations for the short term and for the long term. What do I mean by that? In the short term, if you don't show up tonight and the kids are at school, who's going to pick them up? Who's going to have the authority to pick them up? Do you have those type of documents? How about if you're hospitalized and you cannot speak for yourself? Well, who's going to call in the relatives that can take care of your children the way that you want? So when it comes to young children, small children, making sure that you have documents in place to even raise them if you couldn't is so, so important. And you don't want the court to make that decision, because the judge doesn't know you, doesn't know your family members, doesn't know who you would choose for this so important task, right? So when it comes to adult children, it's a little bit different, because they may need asset protection, protection from if they were involved in a divorce or a lawsuit, would your assets be lost to those third parties claiming, right, in a lawsuit, in a divorce, things like that. So you want to make sure that the money that you leave them, their inheritance, is protected for them and only for them, the way that you want, the way that you would do it if you were here and you had not distributed these assets to them. So understanding these differences ensures that your plan meets your family's unique needs. It's not a one size fits all. So there's some common mistakes and when it comes to leaving money to your kids. How to leave money to your kids. Some people say, well, a will, they're named in my will. And of course, we just talked about how that could be a problem. It could have unintended results. It's also very costly and it takes a long time. It's something that can be avoided. We're going to talk about how to avoid that. Um, some people also say, well, I've already taken care of it. I've named my children on all my bank accounts. If anything happens to me, they're already in charge and they already have it. Well, that can also have unintended consequences, risks. Remember that if they get into a lawsuit, if they get into a divorce, those assets could be counted as their own because they are, even if they're added to the account and you're still on the account, it is still something that can be a risk, right? So passing property to children, um, even real estate, sometimes it can be a problem even for them. Now they may have an issue, they may have a lawsuit, and now it is known that they also are entitled, are on the title to your home, right? So even though they may say to the insurance company or the person suing them or in the, well, no, this is my parents' home, it's not really mine, but they don't care about that because your name is on the title. So you're going to be also looked at for whatever you have, whether it's another home, a second home, whatever it may be. So these methods are used and they're common because people want to take matters into their own hands and they think that they can save money. In effect, it's really not a good idea. It ends up wasting and losing a lot of money in many ways. So, something you would want to consult about in your specific situation if this applies to you. I want to briefly mention a case study, the case, we call it John. So, John took matters into his own hands. He added his two children to his bank account, and it was a pretty substantial bank account. It was $500,000. He thought, well, I'll do it, and eventually, at least I know that they have access to the bank account. Well, yes, they had access to the bank account, but John ended up passing away unexpectedly a couple of years later. And what happened? Well, the bank froze the account, at least to get verification, preventing immediate access, right? One of the children was facing a lawsuit at the time that John died. And the creditors immediately attempted to claim half of the money in the bank account, and this even complicated the issue even more. The second child was going through a divorce um, at that time as well. So the spouse also was claiming part of the money in the bank account as part of the divorce proceeds or marital assets that they would be entitled to. At the end of the day, there were attorney's fees, there were claims that had to be paid out, and the kids ended up getting almost nothing. So, was this a good decision by John? Did it save him any money? No. And there were so many other options that he could have done, and he didn't. So we don't want that to happen to our clients. And when we meet with our clients, we explain the risks of what they have right now. We start with an inventory of their assets, what the law says about that, their family structure, and more importantly, their desires, so that they can have peace of mind that they've made the right decision. And it's all actually a very cost effective way of doing it when you think about what would happen if, and what would be the cost if they didn't plan. So, what are the risks of the direct transfer without the plan? We talked about probate, and we talked about briefly what probate is, right? Where the money and the assets could be tied up for months, even years. In Florida, it could be between an average of 9 months to 16 months if there are no conflicts and lawsuits and claims and things like that. Otherwise, it could be years. So it's expensive. It's a court process where attorney's fees alone by statute in Florida can be 3% of the estate if it's under a million. If it's over a million, then it could be 2.5. But think about the amount of money that is. So if you have a home and you take the value of the home and you take value of any bank accounts, investments, things like that, well, that's easily going to probably be more than a million. But even if it's just a million, we're talking about $30,000 just in attorney's fees. And when we talk about attorney's fees, that's not all. You get also other fees, appraisal fees. We're going to talk about a little bit about the fees in a minute. But there's also the issue of management. The funds can be lost to creditors, to lawsuits, poor financial decisions. And like we mentioned before, conflict and disputes. And also, your kids, when they get it, there's no asset protection. The judge just turns it over to them if they're at 18 years or older, whether they're ready or not. Now, I don't know about you, but when I was 18, if I received 100,000, 500,000, a million, oh my gosh, I don't know. I don't think I would have made the right decision for that money at that age. And I don't know about you, but in my situation, for my children, even though they're very responsible, they're young. They don't have the experience to manage money like that. So this is something that you can put in place, how they receive the money, when they receive it. And these are not things that you can put in a will because the judge is not going to enforce it. Another thing that you need to know about a will is that it doesn't take effect until you die. So there are other documents that you would want to put in place to have a complete estate plan. We're going to discuss that, and those can involve powers of attorney. Because remember, the will doesn't have any power until you die. It could also include healthcare directives, living wills, so things that can help you when you cannot take care of yourself, and you can name the right people to do that for you. So these are some of the reasons why it requires a plan, leaving money to your kids and not just taking matters into your own hands, because it is very risky to just do your own plan and take matters into your own hands. We see all too often people come in and what they have is a situation where the father has passed away, but now the kids are involved in this probate process. And one of the questions that they often ask is, oh, did my father know that this would happen? Did he not think about putting a plan in place, even though it's a loving father that we're talking about? He didn't know. So you don't know what you don't know. And this is one of the reasons that we often train or give these presentations to just make you aware of what the risks are. You can prevent frozen accounts, you can minimize tax burdens. This is something that you can put a plan in place to make sure that leaving money to your kids is the right way, the way you're doing it. And it requires a plan. Without a plan, yeah, your kids are going to be facing possibly a mess, something that is not your intention. You've worked so hard to accumulate what you have, and you raise your children so that they can have the best possible future. And you need to take that a step further to make sure that that happens, whether you're here or not. So, exactly what is probate and why you should avoid it? Well, by now you know that it is a legal process that validates a will, right? And you may ask, well, what if we don't have a will or somebody doesn't have a will? Well, if you don't have a will, maybe the good news is that the government has already put a will in place for you, but may not be good news after all. So this is called the intestacy laws. Every state has one. So in Florida, the intestacy laws would dictate how your assets would be distributed to the heirs at law, right? And this may not be your choice. So this will that is written by law also requires the probate process. So whether you have a will or no will, there's still going to be a probate process if you have assets titled to your name or partly titled to your name. So there is a way to avoid that, and that is with a trust. We're going to talk about that in a minute. But first, let me again go over why we need to avoid the probate, or why it is advisable to avoid the probate. Now, I'm not saying that all cases require a trust. There are some cases where somebody doesn't have a home, they have no assets at all. A will may be enough because, they just want some documents, a will, the power of attorney, healthcare directives, and this is what we call a will based plan. But if you own assets, if you have a home, if you have a bank account, if you have life insurance policies, investment accounts, things like that, you need to consider how things are now and how things would be with the trust and then decide. And those are the kind of cases that we would then say, hey, it may be better for you and your loved ones to save money, to save heartache, to save stress, to save more fees than you really need to by having a different type of plan, perhaps a trust. And we're going to discuss that. But there's also other aspects of the probate process, lack of privacy. So records are public, and this is something that you may want to avoid, right? There could be, like I said, dispute among the children, the heirs, the family, and this could sometimes cause families breaking up for years. And I don't know if you've talked to anybody that knows somebody or that has a family member that has gone through the probate process, and they can tell you. I've heard some horror stories being in the field of being an attorney handling probate and estate planning and asset protection cases. So remember, the creditors get to file their claims first. This is not a benefit to your family. So, fortunately, there are solutions to bypass this entirely. And we're going to talk about the alternatives to a will. What are the alternatives? So, if there's not a will, or uh, there's not doing a will and then having to go through the probate process, what is the solution? So let's talk about one of the solutions, which is the use of trust. So the trust, there are different types of trust, and we're gonna talk about that. But the trust really allows you, if it's a revocable trust, to maintain control of your assets just like you do now. You can go to the bank, take money out, put money in, change your assets any way you want, buy another property, sell your property. You can do all these things just like you do now. But when you die, that trust then becomes irrevocable. Why? Because now your wishes, which are in the trust, is the law really for your family. So it gets to be distributed the way that you want and when you want. So it can protect your children, even if they're going through a divorce, even if they're going through psychological problems, and they're not ready to deal with um, having to go through probate or receiving money and not knowing what to do with it and somebody taking advantage of them. So, yeah, it can protect from lawsuits as well. And the trust can offer bulletproof asset protection for your kids and your loved ones, or even your spouse. So it can also provide uh, help or a way to protect your business, right? As a business owner, if you are a business owner, what would happen to the business if you suddenly weren't here? Well, the business can be part of the trust as well. This is something that sometimes gets overlooked, and we, as part of our inventory, we we ask, do you have a business? Do you own a business? And then what would you like to do with that? And the trust can also be in control of that business. So saves money, it saves time, offers greater control and privacy, and a better asset distribution. So it can provide the asset protection from third parties. Remember that. Ex-spouses, lawsuits, bankruptcies even. So this is something that can bypass the probate process, save money, legal costs, and reduce the delays, and your family can continue the way it is now, managing your expenses, your assets, things like that. So the types of trust. There's a revocable living trust. A lot of cases, this type of trust is either the trust that our clients use or one of the trusts that our clients use. And it depends on your specific situation, your age, your health, your family makeup, and your wishes. So it's a revocable trust. This allows you to maintain control, like I said, over your assets, over everything you have. So everything is kept the same as it is now. Titles are changed to the name of the trust, but you as the trustee. So you get to wear three hats. You're going to be the trustee because you're going to manage and control everything for as long as you can or you want to, for as long as you're alive, right? So there's also the trustor. That's also you. It's always going to be you. Why? Because we're talking about your things. We're talking about your assets. So you're the trustor, you're creating the trust and putting it into the trust, right? You're also the beneficiary. While you're alive, you're receiving, you're managing, you're living, and you're making decisions. And you can take a trip and spend the money that you have in the bank account, even if it's under the name of the trust, because you're still the beneficiary of the trust. So this is the revocable living trust. Now, and I want you to think of it as like a treasure chest with an open lid. It's an open lid. And in this treasure chest, funding the trust just means that we're retitling the title to your home, whether it has a mortgage or not, it doesn't matter. It's not a violation of the mortgage to put it into the trust, and it is by law one of the things that is allowed without violating the terms of the mortgage, that you get to put your title to your home into the trust and continue paying your mortgage just like you are now. It could be that you have property in another state or another county. This could also be retitled to your trust. That means funding the trust. So funding the trust does not mean, oh, I have to go get money. I don't have enough money to have a trust. It's what you have now that qualifies you to have a trust. And funding the trust just means retitling. We do that for our clients as part of our representation. So this is a revocable living trust, right? A treasure chest with a lid open. Why? Because you can take things out, you can put more things in. And hopefully, if you get more wealth, you will have an opportunity to grow this treasure chest, right? So the moment you're no longer here, there's a successor trustee that will take this treasure chest, now with the lid closed, but will be able to distribute the assets the way that you want, how you want, when you want. Now, an irrevocable trust, this is a type of asset protection trust. It provides a stronger asset protection while you're alive for you, your heirs. It is difficult to change once created, and we discuss those on a case by case basis. Sometimes, when there are health concerns or when we need to protect assets because of lawsuits, things like that, we discuss those. Okay, so there's also special needs trusts, and these are specialized trusts when someone needs to be taken care of and they're a loved one that may need a special trust. We discuss those as well on a one-to-one basis. So beyond trust, what do we do? Well, we have we do a comprehensive estate plan. We don't just do a document here, a document there. We do a comprehensive plan so when you walk out of our office, you have really the peace of mind that if anything were to happen, you would have named the people that can speak for you if you can't, if you have a health condition, an emergency, an accident, a stroke, debilitating situation. Um, these are health care directives, and we put those in place. Also, living wills. Um, how do you want your emergency medical treatments to go? And who would have the decision? I mean, the power to make those decisions for you or to advocate for you? Who's going to be speaking up for you? Because you're married does not mean that your spouse gets to step in, because the law does not presume that they have your best interest at hand. Imagine spouses that are legally married but separated for years. You wouldn't want that person to step into a hospital and have the power just because they're married to say, oh, I want this treatment or that treatment for my loved one or my spouse. So these are all documents that we put in place, including a very important document. Actually, I think probably the most important of all when it comes to after you put a trust together or putting a trust together, the durable power of attorney. This is appointing someone who can take care of paying bank accounts, mortgages, any of the powers that you have now regarding the management of your assets of your life. Really, this person can have all the powers that you have, because in the event that you couldn't exercise those powers, you would want someone, not a judge, and not the delay of the court, because that process is not called probate, it's called a guardianship. And if you don't have these documents, a guardianship would have to be opened in court, and the judge would decide. It's public, it's costly. Sometimes there are premiums and bonds required of your family member who wants to serve and help you, and now they actually have to do all these things in order to help you. And they may not be the person that you would want, but it's the person that maybe looks good on paper to the judge. So this is a complete estate plan that covers all of that if something were to happen to you. Health care directives, and all of those important decisions that only you would have been able to make if you could. But now that you can't, you've taken the step to name the right people. So this is what we call a comprehensive estate plan, and it's the way that we work. So let's talk about the way that we work. Well, you may be wondering, and you may be sitting here thinking, okay, I want to ask about my own specific situation, and this is called a discovery call. We can schedule a discovery call. It's typically like a 15-minute to sometimes it takes a little bit longer, but we listen to your concerns. We gather a little bit of information about you, about what's keeping you up at night, or what you want to accomplish, what will give you peace of mind. So once we talk about that and we explain a little bit about our process, if you decide, and we also decide that we can help you, then we can take it from there and we can schedule a legacy planning session. So this is a meeting with either me or another attorney in the office that we can schedule. This consultation takes about between an hour to 2 hours. We discuss your concerns, our recommendations, and fees, because we work on a flat fee basis, and I'll explain that in a second. We discuss how we can put this in place. You would sign an agreement if you want to move forward, make a payment, and then we schedule right then and there. The best part, I love this part, because you get to leave this planning session with the date of the signing of your document, typically 4 weeks later. Doesn't need to take months, doesn't need to take forever. This is something that we get to schedule 4 weeks later, where you're going to come in for signing day. So on signing day, you're going to be here in our office signing the documents with our notary, with our witnesses, putting everything in place. And then we schedule after that the legacy planning session where you come back to pick up some recorded documents that we have to record in court. You also come to record, if you wish, messages for your loved ones that will be part of your legacy to them in your own voice. And you will get to explain why you put this plan in place. You get to say as much as you want, but that is a private um, recording that you get to keep for yourself, for your loved ones, as part of your binder, as part of your estate plan. So, this is our process. It takes between 4 to 6 weeks to complete, and you will leave with asset protection for your loved ones, peace of mind, your wishes honored, and much, much more. So, the discovery call, where we listen to your goals, we listen to your concerns and priority, is the first step. And we give you an opportunity to do that here. We're going to have a description in the link, um, or we're going to have a link in the description where you can schedule that call. You can also schedule that call by calling our office, and we're going to have that number available to you, and it's also available here on the description. So I want to tell you a little bit about the difference between us and perhaps other firms. And I tell you this because many clients tell us, oh, they charged us by the hour, or there were extra fees that we got billed for. And this is not the way we work. You know, the flat fee according to your wishes, the type of planning that you choose, and you pay in advance. There's never a surprise, right? And we think of ourselves as a partner of you and your family for life. We are your attorneys for life. So it's a representation that doesn't end. You can always call us, and consultations are free. You can ask questions. We have a copy of your documents, of your planning, so we know what answers we can give you that will help you, right? So we're available. We're part of your extended legal resource for you and your family, really forever, right? So we protect what's most valuable to you, and this is your family, you and your family, and of course your business, your assets, and your legacy. So not just a transaction. You're never just a transaction. It doesn't end the day that you sign, even the day that you receive your binder or your legacy resources. No, it doesn't end there. It begins there, really. We focus on long term relationships. And our best clients are referred by former clients. This speaks volumes to us, and it really motivates us to do this type of work because we see how lives are changed all the time. So, the legacy planning session, we map out at this session your wishes. We already have an inventory at this point of your assets, right? So we map out a plan that aligns with your goals and with your family structure, right? It's personalized. It's never form documents, or we use the same plan from somebody else, because everything is custom made, right? So it's specific to your wants, your needs. We collect a detailed inventory of your assets. We discuss the funding of your trust, which we take care of. Changing titles to your bank accounts, your investment accounts. We're always at hand. We can't go to the bank for you to change your title to the bank account, but we can speak to your banker if there's any issue, or send any copies of documents that they may need. So we're your resource, we're your advocates, we're your legal representatives. So all of this happens while we schedule your signing date to finalize the plan. And when you leave, the signing with peace of mind, that is our biggest reward. That we know that you're protected no matter what happens in your life, and no matter what surprises life may throw at you. So, our promise to you, yeah, we provide peace of mind, and we're always available to our clients. We provide with a comprehensive strategy. It is a legal strategy because every asset is different in every family. and it means a different thing. You may have an asset that you don't want ever to be sold. It's a family heirloom or family farm or a family house that you want your kids to be able to go to if they need to, or you want it to be rented but not sold, things like that. Every family has like a different type of desire, and we work with those. We partnership with your desires to put that planning in place. So we told you a little bit about the signing date and our promise. Now it's your turn. Now, remember, information is not power unless you put it into action. So we do want you to have the power. Having received this information, going to book a call. I'm even wanting to encourage you by giving you a $250 discount to whatever plan you choose, just to book a call right now and have attended this workshop. I know that you have learned, so it also makes it easier for me, right? Because you're going to be more on point as to what questions you have. So book a call by either going to the link of calendly.com/legacy planning. You can also call us at 305-514-0608. But remember, mention that you were at this workshop so that we can apply that $250 discount for you. Now, when it comes to the legacy planning sessions, those are limited. We only have typically about 4 to 6 available every month. We're a small law firm and we work on a case by case basis. So it is very important that once you book the call, if you want to move forward with that legacy planning session, that you book it during that 15-minute phone call. We can book it for you, or you can go online and book it yourself when we give you the link. But those are limited. In March, for example, there's 3 left, and in April we have, I think in April we have 5. So you can book those, but when they're taken, then they need to be booked out in advance. So I hope I'm going to go through some Q&A, some question and answers. Some of you have submitted some questions, so we're going to go through these. We have a few minutes left, and I also want to put here on the screen our contact information. Our phone number is 305-514-0608. Our website is Legacy Trust Counsel, and you can Google us and read what other clients have had to say. And this is our address here in Doral. One of our addresses, we have other offices that if they're more convenient for you, Coral Gables, Brickell, Fort Lauderdale. So book a call right away if you can, and we'll be happy to talk to you, and I hope to see you on the inside. Now I'm going to go briefly through the Q&A. Um, we have a question. How can I help my children avoid probate when I build my estate plan? Well, I think that we answered some of that, but in your specific situation, we would want to know more about your assets, right? So avoiding probate just means that if something happened to you, or when something happens to you, any assets that still have your name on it is going to have to be handled in probate. So there's only 2 ways really of avoiding probate, and that's retitling your assets. Whether it's going to be to a trust, which is our recommendation, or if you have other means, like if you want to put like your beneficiaries, the person you loved, you want to leave it to their name on that particular asset. We spoke about the dangers of doing that, and the risks, and the possibility of other complications and legal fees and such. So, but avoiding probate, it requires going to an attorney. Hopefully, it will be us if you want us to represent you, but it's creating an estate plan that does not leave any assets at risk of going through the probate court process by retitling them to your trust. Okay. Next question: How do I need a will if I have beneficiaries listed on my accounts? Well, I think we went over that a little bit, but just briefly, remember what happened to John in the example that we gave. So, even if you have beneficiaries listed on your account, having a will is still recommended because you never know if there's going to be conflicts or claims. And at least if you have a will, it will give the direction to the judge of who you would want those assets to go through. To go to. Um, so that may be, but of course, the will, as you know, does not avoid probate. So there could be other options that may be better for you. Next question: how can I prevent my assets? A lot of people are wanting to avoid probate, and we keep all of these questions that came up is avoiding probate, preventing the assets to go through probate. So as we spoke, creating a revocable living trust accomplishes this. And during your lifetime, you don't lose control. It's a treasure chest with the lid open. Remember that part. So you can also um, design or create um, a revocable and an irrevocable if you have some assets that requires that lid being closed. So properly titling or retitling assets to the trust will help bypass the probate process, and they can be given by your successor trustee directly to the beneficiary that you choose. So this is really, really important, a way of avoiding probate, and is one of the tools that we use. There's an interesting question about overseas investments and can they be covered by a US trust? There are different types of trusts. So, yes, there are trusts that can hold overseas investments. Those are very specific um, planning tools that we need to discuss and consult on a one to one basis. And depending on the asset, the jurisdiction, what you want to accomplish, things like that, then we will give you the advice to be able to do that. And if you want to move forward with that, give you the planning. Okay, what happens? And this is the last question that we have time for here. What happens if I die without an estate plan? So, if you die without an estate plan, and by the way, you're not alone, over 70% of people do not have any estate plan whatsoever. And even the rich and famous, I can tell you that when Aretha Franklin died, she did not have an estate plan. Millions of dollars were lost, over $40 million in litigation, lawsuits, probate, because there was even a handwritten will or a couple of them. They had conflicting information as to whether it was going to be one son or the other son, the one receiving the majority of the assets and whatnot. And it ended up a lot of pain, family conflict, drama, something she would have not wanted, right? So she died without a complete estate plan. And we don't want that to happen to you. So what would happen is that there would be the probate process, litigation, lawsuit. And at the very least, there's going to be costs, delays. And even if your family is in agreement and they get along, they don't want any issues, even just that, remember the percentage that I told you, just an attorney's fees. But there's going to be other fees, filing fees, um, appraisal fees. There's going to be bonds, premiums. There's going to be all kinds of fees that you can avoid and money lost, right? There could also be tax advantages that you're going to be missing on. So, all of those issues are resolved by a complete estate plan most of the time, or most of them. And this is something that you can discuss with us according to what your family structure is, your desires, and according to what your assets are. We start with that inventory of your assets, what would happen now, and how we can better that, and what would happen with a proper plan in place. I hope that this was informative to you, this was important, but remember, the power is in taking action. So we hope to see you on the inside. Thank you so much for being here. And like I said, we're here to partner with you for your best legacy and for your best peace of mind when it comes to your estate. Thank you.